Now, after a short break, this is the further understanding of the stipple by the discussing the kinds of the stipple. So, what are the kinds and what are the further doctrines which are related with the stipple? So, kinds there are three kinds of the stipple, and here's the I'm going to share with you slide of kinds. Okay. I hope slides are clearly appearing on your screen. So, students, I would like to invite your attention towards that slides. The kind of stipple, the principle of stipple is classified under three heads in English law, in a legal language, in a legal field. There are stipple by record, stipple by deed, and stipple by conduct or pass. So usually the kinds of stipple are different kinds of stipples. So what is stipple by the matter of record? The matter of record is something part of the record of the court. It is at once the narrative and the proof of its proceedings. Stipple by record results from the judgment of a competent court. The law allows a party ample opportunity. Law after the judgment of the court, law will give the appeal opportunity by way of appeal and otherwise of upsetting a wrong decision. And if that party, if he or party takes the opportunity and fails or does not choose to avail himself of it, thereafter he cannot subsequently reopen or dispute that decision. So that is the stipple by the record. If there's a judgment which is available in record in the court of law, and that is the valid judgment passed by competent court. So by way of res judicata, any other litigation will not proceed on same nature between the same parties on same cause of action. So this is the stipple by record. So another kind, that is stipple by deed, where a party has entered into a stolen engagement by deed as to certain facts. Neither he nor anyone claiming through or under him is permitted to deny such facts. This is the subject to certain qualification. Qualifications: number one, the rule applies only between the parties and privys and only in actions on the deed. No stipple arises upon recitals or description which are either immaterial or not intended to bind. So stipple by deed only applies between the parties, and their binding recitals will apply not all the recitals which are defined in the deed. No stipple arises where the deed is tainted by fraud or illegality. If deed will obtain or created by fraud or any other manipulated way, so thereafter the stipple will not apply. A deed which can take effect by interest shall not be constituted to take effect by the stipple. So this is the stipple by the deed. Means there's the agreement. There are a lot of agreements actually we find in the field of law: a sale deed, sale agreement, rent agreement, lease deed, and other kind of agreement which party created and bind themselves to follow the certain recitals. So those recitals which are binding between the parties, they will not thereafter deny those bindings, and they will not say that they are not apply as deed was created. So it is a stipple by deed. Deed will restrict them, deed will bind them to follow what they have decided in past. So, and another kind of stipple by conduct. The following are the recognized propositions of the stipple in a conduct. If a man by his words or conduct willfully endures to cause another to believe in a certain state of things which the first which the first knows to be false, and if the second believes in such state of things and acts upon his belief, he who knowingly made the false statement is stopped from averring afterwards that such a state of things did not in fact exist. Number two, if a man either in express terms or by conduct makes a representation to another of the existence of a certain state of facts which they intends to be acted upon in a certain way, and it be acted upon in that way in the belief of existence of such a state of facts to the damage of him who so believes and acts. The first is stopped from denying the existence of such a state of facts. If a man, whatever his real meaning may be, so conducts himself that a reasonable man would take his conduct to mean a certain representation of facts, that if it was a true representation and that the latter was intended to act upon it in a particular way, and he with such belief does act in that way to his damage, the first is stopped from denying that the facts were as representative. If in the transaction itself, which is in dispute, one has led another into the belief of certain state of facts by conduct of culpable negligence calculated to have that result, and such culpable negligence has been the proximate cause of leading and has led the other to act by mistake upon such belief to his prejudice, the second cannot be heard afterwards, is against the first to show that the state of facts referred to did not exist. So these are the three kind of estoppel: estoppel by the record, and estoppel by the deed, and estoppel by the conduct, when a person by acts or words or deeds induces another person to believe the existence of things and make him to act upon it. For example, the person who induces another is stopped from denying the existence of such fact. So there are a lot of other kinds, estoppel by election, estoppel by promissory note. So when you will start to read the estoppel, you will find a lot of other various kinds of the estoppel. So these are the main kinds of estoppel: estoppel by record, estoppel by the deed, and estoppel by the conduct. So these are the certain estoppel you can study and you can discuss. So further, this is the understanding of the article number 114, and article number 115 and 16 both are interrelated with each other. Both govern the certain legal relation between the parties by the certain deeds. As per the article number 115 says that once tenant accept any landlord as a landlord, thereafter he will not challenge the title of the landlord. And also 150 इसमें एक maximum भी है कि there is a principle कि once a tenant is also always a tenant, कि आपने किसी को अगर landlord accept कर लिया है तो tenancy जो agreement you will bound by the terms of the tenancy, and you will not deny on the that plea कि that person is not my landlord, or you will not supposed to challenge the title of landlord. So because you have no right to challenge, because you have accepted as a landlord, now you cannot claim any other right on that property. You will remain tenant until unless it is your burden, you have to prove your another right on the property. तो इसी तरह जो है उसमें फिर जो आर्टिकल नंबर 116 है उसमें जो स्टेपल जिस तरह किसी को आप जो है बिल ऑफ एक्सचेंज जो है वो ड्रॉ किसी को एक्सिक्यूट करते हैं, या किसी को आप लीज एज ए लेसी आप किसी के साथ रिलेशन बनाते हैं, या आप जिस तरह लॉ ऑफ कॉन्ट्रैक्ट में जो है बेलमेंट का लॉ है, एक बेलर होता है, बेली है, तो ये जो रोल है इस अब ये आपको तब समझ में आएंगे इफ यू हैव स्टडीड द इंस्ट्रूमेंट एक्ट, जिसमें इंस्ट्रूमेंट, व्हाट इज द इंस्ट्रूमेंट, व्हाट इज द बिल ऑफ एक्सचेंज, व्हाट इज द प्रॉमिसरी नोट, एंड यू हैव आल्सो स्टडीड द कॉन्ट्रैक्ट एक्ट, जिसमें कॉन्ट्रैक्ट के में किस तरह लीगल रिलेशन बनता है दो पार्टीज के दरमियान में, और उसमें फिर जो है बेली डिफाइंड है, बेलर डिफाइंड है, और बेलर क्या है, बेली क्या है। तो ये टर्म्स फिर आपको समझ में नहीं आएंगे, हाउ दैट स्टेपल विल ट्रीट जो है वो बेलर और बेली को किस तरह इस पे अप्लाई होता है, और कॉन्ट्रैक्ट पे ये किस तरह अप्लाई होता है। और इसी तरह लीज डीड है, जिस तरह लीज और लाइसेंस जो है ईजमेंट में है, लीज जो है वो आपके जो है ट्रांसफर ऑफ प्रॉपर्टी में डिफाइंड है, नहीं सॉरी, लीज जो है आपके कॉन्ट्रैक्ट एक्ट में डिफाइंड है। तो ये जो कॉन्सेप्ट है, हाउ यू विल नो, ये आपको कैसे पता जब आपको ये चीजें पता नहीं होगी कि लीज क्या है, लेसी क्या है, और बेली बेलर इनका रोल क्या है। तो 117 कहता है कि अगर ये वंस रिलेशन दोज हैज बीन क्रिएटेड बाय अ लीगल document, then parties will bind, they will not thereafter deny their relation, and they will not challenge the relation of the जो है once you have accepted। अब लेसर को, लेसी जो है लेसर को एक्सेप्ट कर लेता है, या बेली जो है कोई चीज जो है वो किसी को वहां पर डिलीवर करनी है, तो एज अ बेली जो है वो कोई चीज ले लेता है, तो वो फिर उसका वो मालिक नहीं बनेगा, वो जो है बेली रहेगा। उसी तरह जो लेसर है, लेसी है, तो लेसी ऑलवेज लेसी जो है वो लेसी रहेगा, लेसर वो उस लीज को, उसके टर्म्स को वो चेंज नहीं होगा। जिस तरह ड्रॉवर और ड्रॉवी है, जिस तरह बिल ऑफ एक्सचेंज में, किसी बिल ऑफ एक्सचेंज जिस तरह हम किसी को चेक इशू करते हैं, तो उसमें एक ड्रॉवर होता है, एक ड्रॉवी, जो जिसको बिल ऑफ एक्सचेंज देंगे, तो उसको फिर आप वंस जो उसका जो है उसको फिर इट इज योर ड्यूटी, उससे आप रिलेशन से डिनाई नहीं कर सकते। यू विल नॉट जो है बाद में आप अपना इरादा आपका चेंज हो जाए, तो फिर चीज को आप वंस आपने लीगली किसी के साथ कोई रिलेशन किसी इंस्ट्रूमेंट के साथ बना दिया लीगली, तो देर आफ्टर यू विल नॉट जो है आप उससे कोई ऑन द कॉन्ट्ररी आप कोई स्टेप नहीं ले सकते। तो ये तो थे कुछ प्रिंसिपल। अब आ जाए एक हम दो केस लॉ डिस्कस करते हैं इन ऑर्डर टू फर्दर अंडरस्टैंड जो है इसको हम जो है फर्दर समझने के लिए जो है उसके जरूरी है कि हम कोई केस लॉ जरूर पढ़ें। विदाउट केस लॉ जो है आपको कानून के कोई भी सेक्शन या आर्टिकल जो है प्रॉपर आपको उसकी समझ में नहीं आएगी, उसकी इंटरप्रिटेशन। तो ये एक PLD 2015 सुप्रीम कोर्ट पेज नंबर 212 उसका प्लस टर्म डी है कि आर्टिकल 114 स्टेपल स्कोप वेयर अ पर्सन वाज aggrieved of a fact he had a right rather a duty to object thereto to safeguard his right, and if such a person did not object, he shall be held to have waived his right to object and subsequently shall be stopped from raising such objection at later stage. Person was stopped by his own conduct if he though was aware of the certain facts, which was likely to cause harm to his rights and adversely affect him, and was prejudicial against him overtly or through some conspicuous act or by omission intentionally permitted and allowed to another person to believe a thing to be true and act on such belief without taking any steps to controvert or nullify such adverse fact. Instead, they slept over the matter. Such waiver or estoppel may arise from mere silence or inaction or even inconsistent conduct of a person. तो ये जो पहला केस लॉ था ये डिफाइन करता है कि जब आपका राइट कहीं पे रेज होता है तो यू हैव टू राइटली एंड टाइमली रेज दैट ऑब्जेक्शन, अदरवाइज एट लेटर स्टेज विल नॉट टेक योर साइलेंस प्रेज्यूम टू बी जो है वे फ्रॉम योर जो है राइट। आप अपने राइट से जो है साइलेंस आपकी जो है किसी भी जगह पे, तो वो उसको जो प्रेज्यूम करेगी कि उस राइट को आपने वेव कर दिया। ये PLD 2015 बलूचिस्तान पेज नंबर 41 प्लस टर्म ए है कि एक सूट है कि सूट फॉर स्पेसिफिक परफॉर्मेंस ऑफ द कॉन्ट्रैक्ट देयर इज अ मैक्सिम स्कैंडम एलिगेटा एट प्रोबेटा द प्रिंसिपल ऑफ एप्लीकेबिलिटी डिपार्चर फ्रॉम प्लीडिंग्स जनफ ऑफ अटॉर्नी नोवेशन ऑफ द कॉन्ट्रैक्ट ex parte evidence and affidavit of the plaintiff was outright departure from the pleadings. Amendments made in the pleadings did not constitute evidence. Evidence laid by the party in support of his pleadings should be consistent with therewith. Pleadings could not be departed except by way of amendment. Anything stated outside the scope of such amendment could not be looked into. Rule of scadum allegata or probata would not only exclude the element of surprise but also preclude the proving the facts which were not contained in the pleadings. Plaintiff himself had established a novation of the original agreement by introducing general of attorney on the basis of which he himself transferred the subject matter in the favor of the defendant. Plaintiff was stopped by his own conduct. Appeal was dismissed in circumstance. So ये जो केस ला है इन दी सपोर्ट ऑफ स्टेपल ऑफ द कंडक्ट के स्टेपल ऑफ कंडक्ट जो है हाउ इट स्टॉप अ पर्सन थ्रू हिज कंडक्ट के उसका कंडक्ट जो है उससे जिस तरह प्लीडिंग्स ये जो मैक्सिम है कि आप जो कोर्ट में प्लीडिंग्स लेके जाते हैं देयर आफ्टर यू विल नॉट टेक अनदर प्ली यू विल बाउंड योर प्लीडिंग्स you will not go beyond your pleadings and you will not surprise the court by taking another जो है ground. अनदर जो है प्लस टर्म बी है इसी केस लॉ की के आर्टिकल 114 स्टेपल मीनिंग स्टेपल वुड ओनली मीन स्टॉप समवन वुड बी स्टॉप फ्रॉम सेइंग समथिंग और अदर और डूइंग समथिंग और अदर और कंटेस्टिंग समथिंग और अदर मतलब कि वो कुछ कह रहा है वो कर कुछ रहा है और वो जो है केस में जो है कंटेस्ट कुछ कर रहा है तो इन चीजों से कोर्ट जो इसको इन हरकतों से रोकेगी कि भाई यू मस्ट बाउंड विथ योर प्लीडिंग्स एंड डू नॉट टेक वन प्लीड एंड अनदर प्लीड एंड अनदर टाइम कि एक वक्त में आप कुछ कह रहे हैं दूसरे वक्त में आप कुछ कहें तो इसकी कोर्ट इजाजत नहीं देती. तो फर्दर ये केस लॉज हैं जो जिसमें मुख्तलिफ जो प्रिंसिपल हमने डिस्कस किए इन स्लाइड्स में या इन आर्टिकल्स को हमने जब स्टडी किया तो उससे जितने भी प्रिंसिपल हैं फर्दर इस केस लॉज को जब आप स्टडी करेंगे तो वो ऑलरेडी आपके स्लाइड्स जब स्लाइड्स को पढ़ेंगे तो ये सारे केस लॉज में जो उसके साथ अटैच हैं तो उसको आप जब रीड करेंगे तो आपको उसकी मीनिंग अच्छी तरह तो समझ में आ जाएगी. तो स्टूडेंट्स ये तो था जो ये तो हमने what we have learned the principle of the stepple at depth along with the all articles 114, 15 and 16. ये तीनों आर्टिकल जो बहुत इंपॉर्टेंट है इनको हमने स्टडी किया डिस्कस किया. आई होप कि दिस लेक्चर जो है विल गिव यू द important knowledge regarding the stepple. Now you are able to apply this principle in the field of law and you will not feel any difficulty when someone will ask you what is the stepple, what